This is Bloomberg Law with June Grasso from Bloomberg Radio.
Chief Justice John Roberts repeatedly stresses the importance of judicial independence. In an interview in May, he said the judiciary is a co-equal branch of government.
Its job is to obviously decide cases, but in the course of that, check the excesses of Congress or of the executive, and that does require a degree of independence.
However, in its recent term, it doesn't appear that the Supreme Court did much to check the excesses of the current executive. In fact, the clear winner of the term was President Donald Trump, as the court sided with him on broad legal questions and emergency requests to let his policies take effect, from throwing transgender service members out of the military to opening hundreds of thousands of migrants to deportation. And for the second year in a row, the court ended the term with a decision handing Trump a major victory by essentially eliminating the main tool courts have used to thwart his ambitious agenda, the nationwide injunction.
This was a big one, wasn't it? This was a big decision. An amazing decision, one that we're very happy about.
Like almost all the high-profile cases of the term, the court divided 6-3 down ideological lines, with the conservatives in the majority and the liberals dissenting. Joining me is constitutional law expert Michael Dorf, a professor at Cornell Law School. Mike, the finale of the term, if you will, was the decision in the case over Trump's ban on automatic birthright citizenship, where the conservatives stripped the lower courts of the power to grant nationwide injunctions, which have really been the only effective check on the Trump agenda. Trump thought the decision was important enough to call a press conference. How important do you think it is?
That remains to be seen. The prohibition on most universal injunctions will have very serious bite if, but only if, the court makes it difficult for plaintiffs to bring class actions and makes it difficult for states to sue for statewide injunctions. Those are two potential workarounds, neither of which the majority directly addresses, but both of which Justice Alito in his concurrence suggests should be only available under a heightened standard of sorts. Right? So what remains to be seen is whether plaintiffs challenging these executive actions, here it was the birthright citizenship order, but it applies to virtually everything, whether they can quickly convert to class actions and whether states can bring these cases. If they can, then I think this ends up not being such a big deal.
Getting class action status is a lot more complicated, and I think, we've seen just in the last few days how confusing it is for the lower courts to parse through this.
I think that's right. The Supreme Court could have, and in my view should have, given more guidance on whether class actions are available and under what standard. One of the things that I think is easily overlooked is the ruling in the case is not a constitutional holding. The court doesn't say that the Constitution forbids this kind of equitable relief. What it says is that this power was not conferred by statute on the federal courts. Well, if that's the case, it's possible that Federal Rule of Civil Procedure 23, which is the class action provision that was empowered by the Rules Enabling Act, that does confer this power. And that would be fully consistent. It would just lead to, the availability of similar relief under a different mechanism.
Why is the court allowing this rule to be applied retroactively? Because now President Trump says that the administration is going to move to lift holds that judges have placed on a number of his policies. He mentioned fights over refugee resettlement, federal spending, and sanctuary cities. So, it's going to open up a can of worms.
Oh, I think that's right. I think this is in some ways the basic problem with the Supreme Court these days, which is it's treating the Trump administration like a normal administration rather than one that is committed to sort of pushing the edge of the envelope and getting away with whatever it can. And so, if you were thinking about the system as a whole and what's good for the rule of law, you would have been much clearer in your guidance and in what you're allowing and not allowing.
Justice Sonia Sotomayor, in one of her dissents, said the court was rewarding lawlessness because the Trump administration has repeatedly, either explicitly or not so explicitly, ignored court orders, particularly in the cases of immigration orders.
I mean, I think she's exactly right that it's one thing to say, as the court has said in some of these cases, well, we think the lower courts went too far in issuing this order. That doesn't mean that the administration was permitted to violate the order while it was in force. The normal rule is if you don't like a court order, you appeal it. But unless you get a stay of that order, and until you get a stay of that order, you have to comply with it.
Often, the Chief Justice is the one who writes the majority opinion in the biggest cases of the term. Why do you think he chose the second most junior justice, Amy Coney Barrett, to write this majority?
Well, I think there's a little bit of sort of doctrinal favoritism going on here. So the decision in Trump v. Casa relies on a precedent called Grupo Mexicano, which was written by Justice Scalia, who was, of course, the justice for whom Justice Barrett clerked, and she sort of sees herself in many ways as trying to carry out his legacy. So I think she was very much interested in applying Justice Scalia's view, which was that courts of equity have only the equity powers that they had in 1789, a view which, by the way, I think is somewhat far-fetched, but that is the precedent. And so it sort of fell into her wheelhouse. It turns out it's a very important case, but I think it was given to her because it was seen as falling within her area of some special expertise and interest. Let's
turn now to a decision that has implications for transgender youth in more than half the states. The Supreme Court, in another 6-3 decision down ideological lines, upheld Tennessee's ban on gender-affirming care for transgender minors. Transgender advocates say the decision is devastating for LGBTQ youth and their families in the 27 states that have similar bans. Here's Kelly Robinson, the president of the Human Rights Campaign.
You're going to have families that have been in states that they live in for generations. I know a family that's been in Arizona for generations and generations. They are Arizonans. They're going to have to leave their states just to get access to care for their kids.
In Justice Sotomayor's dissent for the liberals, she said this decision will open the door to more state discrimination against trans teens and authorize, in her words, untold harm to these families. Mike, the issue here was whether the law violated the Equal Protection Clause?
Yeah, that's right. The underlying litigation raised a number of other questions, including whether this violated the sort of bodily autonomy or substantive due process rights of the minors, the rights of parents to make medical decisions for their children. But as it came to the Supreme Court, the only issue was whether this was a violation of equal protection. And the court, in a sense, I wouldn't say ducked that issue, but sort of mooted it by saying, well, there isn't a sex-based classification or even a transgender identity-based classification at issue here, so we don't have to apply the intermediate scrutiny that would normally apply to such laws, and therefore we only have to say whether it's rational, and of course states get to make all sorts of medical judgments, and you subject those to rational basis scrutiny, they're almost always going to survive. So in a sense, the case doesn't tell us that much about the status of discrimination on the basis of transgender status under the Constitution going forward, because the court said, well, we don't have to address that here, except that several justices in concurring opinions did address that and said, even if it is transgender-based discrimination, that's okay because that kind of discrimination doesn't trigger any heightened scrutiny. They didn't say that about sex. What they said there was that it's not sex-based discrimination. And in that sense, those concurring justices differed with respect to their constitutional analysis from what the court said a number of years ago as a matter of statutory interpretation in employment discrimination cases.
I mean, the same drugs that Tennessee bans for the purpose of gender-affirming care for transitioning minors are allowed for a number of other purposes in non-trans minors. How do they get away from saying that's not an equal protection violation?
Right. So the plaintiffs and Justice Sotomayor in dissent, I think, are very clear. Look, if a boy wants to take this drug to give himself facial hair, you allow it. If a transgender boy who is assigned female at birth wants to take it, you disallow it. It's the same drug, same effect. How could that be anything other than sex discrimination? And what the court says is, well, it's not the same treatment if it's being prescribed for a different condition. In the boy who's taking this to give himself facial hair, it's being prescribed because he has low testosterone. In the transgender boy who's assigned female at birth, it's being given to facilitate sex transition. And that, the court says, is a different treatment. Now, they analogize to something like, different off-label uses. So that something might be approved for as a treatment for hypertension, and people discover, hey, this also can cure baldness. Normally, if a drug is approved for one purpose, it can be prescribed off-label, but states can forbid certain off-label uses if they think the risks and benefits are different. So that's the analogy that the majority draws. The difficulty with that, as I think Justice Sotomayor convincingly says in dissent, is, well, here what makes this a different treatment is simply the sex assigned at birth of the person taking it, and you're sort of gilding the lily or double counting by working that in.
So the three conservative justices you were referring to who wrote concurrences, would they reject intermediate scrutiny for any anti-trans laws?
I think that's right. I mean, Justice Barrett actually is the one who writes most extensively on this, and she says, look, we have criteria for deciding whether something is a suspect or semi-suspect classification, and transgender status doesn't meet those criteria. Now, I think she applies them a little bit strangely. One of the things she says is that in order for something to be a so-called immutable characteristic, it has to be identifiable at birth, and transgender status doesn't emerge until later. Well, that's a kind of backwards analysis because, of course, the whole point of someone wanting to transition to address their gender dysphoria or other mismatch between their experience of themselves and the sex assigned at birth is that what they were treated as at birth was, not accurate. And so it's a very odd thing to say, well, because when you were an infant, you didn't realize, or other people didn't realize, that you were a male inside of a female body or vice versa, then that's not real in some sense. So there's a way in which it's a kind of, denial of the existence of transgender persons at all. I mean, she doesn't say that, but I think that's a logical implication of that particular criterion.
Well, the court also allowed the Trump administration to oust transgender military on the emergency docket without even a full hearing on the merits. It seems like transgender rights are not in favor at the court.
I think that's right. Now, of course, we don't know what the basis for that decision was exactly because it was on the emergency docket without explanation. We do know that there is traditionally greater deference shown to the political branches, both Congress and the executive, with respect to military matters. And so it would be possible to say that transgender status discrimination generally triggers intermediate scrutiny, but not with respect to who can be in the military. There were some cases in the 1990s and early 2000s before the abandonment of the so-called don't ask, don't tell policy, in which courts upheld the ban on gays and lesbians serving openly in the military, even while saying they weren't deciding the broader question of what kind of scrutiny sexual orientation discrimination gets outside of the military context.
Can we read anything into the Supreme Court throughout appellate rulings in favor of transgender people in clashes over health care and birth certificates in 4 states and ordered the judges to re-examine the cases in the wake of this Scrimetti decision? Do we read anything into that?
Oh, yes. So I was trying to be a little bit hopeful there to say that, as a matter of the official holdings, the court has not foreclosed the possibility that sometime in the future it could say transgender status discrimination is sort of presumptively invalid in the same way that sex discrimination is. But reading the tea leaves, I think it's pretty clear that that's not the direction that this court is going. And another way to put that is that they are going to increasingly treat the Bostock decision, which is a case that held that sexual orientation and transgender status discrimination were sex discrimination for purposes of Title VII. They're going to treat that decision as a kind of outlier, the case that gets distinguished. And they specifically say in Scrimeti, well, we're not addressing this Bostock analogy. Title VII might be different. So I think they're teeing that up and sort of cutting back. The anti-trans backlash that we've been seeing in the political realm, I think, is now flowering in the Supreme Court as well.
Coming up next, we'll continue this discussion of the Supreme Court's term. The court once again bolsters religious rights. I'm June Grasso, and you're listening to Bloomberg. I've been talking with constitutional law professor Michael Dorf of Cornell Law School about the Supreme Court's term. There was another case involving LGBTQ rights, and in a 6-3 ruling, once again with the conservative justices in the majority and the liberal justices in the minority, the court ruled that public school parents have a right to opt out of classroom lessons that intrude on their religious beliefs. And in this case, it was because the lessons involved the reading of LGBTQ-themed storybooks. Religion versus issues involving LGBTQ rights, religion always wins in the Roberts Court.
Yeah, that's right. I mean, you can think of this as sort of the finale, for now, of a trilogy that began with the Masterpiece Cake Shop case, continued with the 303 Creative case, and now here we have a similar situation where the religious claim wins out as against the effort to, in this case, have an LGBTQ plus inclusive curriculum. To my mind, what's so sort of surprising about this case is how quickly and easily the court dismisses the administrative burden that it's placing on school districts, right? What the court says is, if there is a burden on religion, then the government, school district, has to give an exemption unless it can satisfy heightened scrutiny. And the burden on religion here is, as the dissent points out, that kids are being exposed to ideas that are contrary to what their parents want to teach them as a matter of religious faith. And if you just think about that for a moment, you quickly realize, well, that could cover a lot of things. There are a great many people in this country who, as a matter of religious faith, don't believe that humans descended from other animals through evolution. Does that mean that religious parents can opt their kids out of biology? People believe, in the millions, that the Earth is only 6,000 years old, even though, geology suggests that it's 4.5 billion years old. Can parents opt their kids out of geology? I think those issues are probably unlikely to arise in large numbers, but the real impact will be sort of these concerted efforts to have parents object to what they see as, some woke curricula on religious grounds. And because the administrative burden is so great, the school district might conclude, well, you know what, it's just easier not to teach this stuff at all. And that is the point that the dissent makes, I think, very effectively.
You mentioned the trilogy of cases, and this reminds me of the 303 Creative case, which involved a website designer who didn't want to design websites for gay marriages. However, she'd never been asked to. And here you have a case where the curriculum for using these LGBTQ books isn't even established yet. It seems like the court is just jumping in before there's a real controversy.
I think a fair criticism of the court would be that in these cases where there are religious objections to gay rights, trans rights, et cetera, that are statutory, the court's standing rules seem to be flexible. You can make a case that there is standing both in 303 Creative and here, but again, some of the same justices who might be sticklers in other contexts, in this context, tend to say, well, of course you can challenge this policy.
And the court is not stepping away from these issues. Next term, it's going to hear a challenge to Colorado's ban on conversion therapy. And the challenge is from a licensed counselor who says she views her work as an outgrowth of her Christian faith. So I think we're going to see the same result in that case. Maybe I'm jumping the gun, but...
No, I don't think you are. And, if you want to sort of juxtapose that with Scrimeti, right? So in Scrimeti, the court is all about giving deference to Tennessee's ostensibly medical determination that it's not in the interests of minors and they're not sort of fully able to give informed consent to have puberty blockers and hormone therapy, right? I don't think you'll see the same kind of deference given to Colorado in its judgment that this kind of therapy is not in the interests of minors.
There were 3 Second Amendment cases, and the justices upheld federal regulations for build-at-home ghost gun kits, refused to give gun manufacturers broad immunity from civil suits, and turned away constitutional challenges to state bans on assault weapons and high-capacity magazines. Does this signal that the court won't eviscerate gun control measures, or is it too soon to tell?
I think it's a little of both. The Vanderstock case, that's the ghost guns case. There, the statute is pretty specific, and you look at that versus the bump stock case that they had where they came out the other way. You can just see those as statutory construction. The same thing goes for Smith and Wesson. I mean, after all, Mexico did lose that case, so they're unable to bring the lawsuit. So I don't count that one as a sort of a pure victory for gun regulation. And then Hansen, which is the case where they denied cert from the District of Columbia, cert denial doesn't set a precedent, and you can make an argument, I think, I think the case involved a limit of 10 rounds on a gun. You can make an argument that the gun that is in common use, that's the term for Second Amendment purposes, is the handgun. And then you ask, well, is it consistent with the history of regulation of guns to limit them to 10 rounds? Well, you're not going to find guns that were capable of firing more than 10 rounds at the founding. So there's a way to get to this result that I think is consistent with what they've said before. And I think it's far too soon to say that the court is sort of easing up on the sort of Second Amendment revolution that it began in 2008 with the Heller case.
Okay, stay with me, Mike. Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Michael Dorf of Cornell Law School. We're going to take a look at the court's emergency docket and how the justices gave Trump some or all of what he asked for. I'm June Grasso, and you're listening to Bloomberg. The clear winner of the Supreme Court's term was President Donald Trump. The court's conservative supermajority sided with Trump on both broad legal questions and an unprecedented barrage of emergency requests to let his policies take effect right away. On the emergency docket, the court allowed Trump to discharge transgender people from the military, fire top officials at government agencies, and open hundreds of thousands of migrants to deportation. The conservative justices repeatedly reinstated Trump policies found by lower courts to be illegal, and it undercut judges who said the administration had violated their orders. I've been talking to Professor Michael Dorf of Cornell Law School. How do you read his wins on the emergency docket?
So I guess I'd say a few things. First, one of the things we didn't talk about when we were talking about Trump against Casa is Justice Kavanaugh's concurrence, in which he says, well, the solution to the problem of universal injunctions is for us to get these cases up here really fast and then for us to decide them because we can lay down the law. And that will be binding nationally. Well, one of the odd things is if that's true, how come they're not doing that? That in a lot of these cases, they're not actually saying, well, here's the rule, and we're deciding on the emergency docket. They're just sort of, reversing the lower courts, giving either no guidance or very scant guidance. And that's to say nothing of whether Justice Kavanaugh's proposed solution makes any sense, given that, putting something on the emergency docket means they don't really have that much time to decide the case, and they don't have full briefing and full oral argument. So you had this remarkable decision where they essentially overrule the Humphreys executor case, which is, a very old precedent, standing for the proposition that Congress can create independent agencies. And, Justice Kagan in dissent says, what are you doing? You barely even mention the case, and you're overruling it. And we haven't had a full briefing or argument on this, and you're reversing the lower court for following our established precedent, which we've told them they're supposed to do. So, the one remarkable thing about what they're doing on the emergency docket is simply, how much law they're making. And now that's not an entirely new phenomenon. They did that in a bunch of religion cases during the pandemic, and they continue to do that. But it is a very strange thing for them to be doing. It is striking how different a position the court is staking out from that of the lower courts. One of the interesting phenomena in this court this year is if you look at the statistics on their plenary docket, they reverse the Fifth Circuit, which is the most conservative circuit, quite a lot. Right? So the Fifth Circuit is getting out ahead of the Supreme Court sort of in being very, very conservative. But on their emergency docket, in these cases challenging Trump administration actions, the court is basically saying, well, the lower courts are too liberal. Now, part of that, I think, is forum shopping by plaintiffs, right? If you're going to challenge a Trump administration policy, you're not going to go to Judge Kazmirek or one of the other judges that Republicans go to challenge Democratic administrations. But I think it also suggests, again, that this court is, not all that skeptical of a lot of what the Trump administration is doing on the merits.
Yeah, the Fifth Circuit has become what the Ninth Circuit was, maybe even more so. In conclusion, how far to the right is the court moving?
I think the answer to that question is very far. I don't think there's any question about that. They did most of the work in prior terms. They overturned Roe v. Wade. They got rid of affirmative action. The religion cases go very far. They invigorated the Second Amendment. So in that sense, their work is basically done on what traditional conservatives care about. To my mind, the question that is most pressing and sort of remains open is not how far to the right the court is moving the law, but how far to the sort of MAGA direction is the court moving the law, or at least allowing the Trump administration to go. A lot of what President Trump and his administration are doing doesn't fall within traditional left-right boundaries. It's just sort of, authoritarian, for lack of a better term. And so it's not surprising to me that, if the Trump administration, wants to peel back transgender rights, that conservatives on the Supreme Court would be on board with that. What is surprising, and I think frankly alarming, is the extent to which the Roberts Court is facilitating the Trump administration's challenges to the rule of law. So what we were talking about a little earlier with defiance of court orders and other things that fall outside the left-right spectrum as we've understood it for the, last 100 years or so, and are on a sort of democracy and rule of law on the one hand versus authoritarianism on the other.
And over the summer, we'll have to keep a close eye on the emergency docket, which I'm sure is going to be very active. Thanks so much, Michael, for your analysis and spending all this time with me. That's Professor Michael Dorf of Cornell Law School. In other legal news today, the jury in Sean Diddy Combs' sex trafficking trial has said that it reached a verdict on 4 of the 5 counts against the hip-hop mogul, but could not reach a verdict on the top count of racketeering conspiracy. The jurors said in a note this afternoon that it was unable to reach a unanimous verdict on the racketeering conspiracy charge because there were jurors with, quote, unpersuadable views on both sides. Joining me to discuss what may be happening with the jury is former federal prosecutor Robert Mintz, a partner at McCarter English. So, Bob, what do you think it means that the jurors couldn't reach a unanimous decision on the top count?
It's not surprising that this has been the most difficult charge for the jurors to reach a unanimous verdict on. The racketeering charge was always the most challenging for prosecutors. It requires proof of at least one other person acting in conspiracy with Mr. Combs to commit two crimes or predicate acts in furtherance of a racketeering enterprise. So it's a very complex charge. It's also the most serious charge. So it's going to be interesting to see what they ultimately do with the charge, whether they are able to reach a verdict or whether ultimately they are hung, which means they could not get unanimity among jurors on that particular charge.
Yeah, rather than taking a partial verdict, the judge told the jury to continue weighing the remaining charge, and deliberations are going to continue. Does it seem to you like they've reached guilty verdicts on each of the lesser charges?
Well, it's always difficult when you have news from the jury that they've reached a verdict or a partial verdict in terms of reading the tea leaves and trying to figure out what it means. Here we have a note from the jurors saying they've reached a unanimous verdict on 4 out of the 5 and that they are hung or unable to reach a verdict on the most difficult charge. It would suggest that perhaps they have returned a guilty verdict. That would be probably what most prosecutors would read into that decision, but we won't know until the verdict is actually read in open court.
It appears that the defense thinks that the jury has reached guilty verdicts on the other counts because Combs appeared morose as his lawyers explained to him what was happening. And Bob, explain where the judge is coming from in ordering the jurors to resume deliberations.
Well, what we have here is a trial that went on for 7 weeks and only 2 days of jury deliberation. So what a judge will typically do, and what the judge in this case has done, is given them what's called a modified Allen charge. Basically, it tells jurors that they should simply go back and continue to deliberate and try to reach a unanimous verdict. It's not that uncommon for jurors to send notes to the judge to say that they can't reach unanimity on some or all of the charges, and then the judge urges them to continue to deliberate, and sometimes they're able to break through whatever barriers they have in reaching unanimity. Sometimes they are unable to reach a unanimous verdict, but typically after only 2 days of deliberations in a trial that lasted 7 weeks and where they heard over 30 witnesses, it's something that a judge is going to ask jurors to spend more time trying to reach a complete verdict, because both the prosecution and the defense would prefer that there is a verdict as to all of the charges here.
And so tomorrow we'll see if that modified Allen or dynamite charge helps the jurors to reach a unanimous decision on that top count. Thanks so much, Bob. That's Robert Mintz of McCarter English. Combs could face 15 years in prison to life behind bars if he's convicted on all charges. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.